Actually, the appellee, we may
She asked if I cared which side, and I'd much rather have this table, Your Honor.
we can switch back over.
Would you prefer, Your Honors, if we?
It's always good to twist the mind.
Excellent.
Are you ready?
I am. One moment, and I will get up to the podium.
Would you like some rebuttal time?
I would, Your Honor. I'd like to reserve 6 minutes of my time for rebuttal.
6?
Just to vary it up a little bit.
Throwing you off today. I'll give you 5.
I'll take the 5, Your Honor.
Okay.
May it please the court. My name is Nick Shanane, and I represent the appellant, Ms. Ashley Scott, formerly known as Ashley Morgan, in this dissolution of marriage case that involves 2 issues of fundamental fairness in a proceeding before the lower court. Those 2 issues are, first, whether it's proper to push a case through trial over a motion for continuance urged by an attorney who pleads to the court that he is not competent to proceed, that he has no ability to properly go through with the trial of the case due to a large number of issues, one of which being just the sheer amount of volume of material that he had to review, but more importantly, the discovery that was not provided led to his inability to properly proceed with trial. Nonetheless, the lower court forced the proceeding to go through, and that was error. The second issue, for Your Honors, is a related issue in that regards, that discovery, that Ms. Morgan had proceeded on at least 10 different attempts with the lower court to compel the discovery, and some of those efforts were granted. But despite the granting of those motions to compel, the trial court said, well, have your CPAs talk with the other CPAs and get it done, and it did get done. There was vast amounts of information that were unavailable throughout the proceeding, and nonetheless, the lower court indicated this is my go time, and you will go. While we all understand and appreciate the great pressures that exist for lower courts, trial courts to proceed in a timely manner, when due process itself is on the line, something must give. And here, the thing that gave was Ms. Morgan's opportunity to have a fair trial. So what's before Your Honors is on the motion to compel. This court has cited on multiple occasions, first, the recognition that trial courts must have broad discretion to grant or deny continuances. We all agree with that concept. But then this court continues to adopt a 3-prong test. And it's not a test, it's factors. It's not that you have to meet all 3 or you have to show one instead of the others. It's simply that these are the 3 factors that the court should consider, and this court has considered multiple times when reversing a lower court's decision not to grant a continuance. Those cases, Barron versus Barron, Ramadan versus Ramadan, Fazzi versus Fazzi, all second DCA, all saying that it was error for the lower court, that the lower court abused its discretion not to grant a continuance when it considered these factors. Those factors are whether the movement suffers injustice from the denial of the motion, whether the underlying cause of the motion was either unforeseen or whether it was based on dilatory tactics, and whether prejudice and injustice will befall the opposing party if the motion is granted. Here, those factors easily lie in favor of the lower court having to grant a continuance under these unique circumstances. Whether the movement would suffer an injustice from the denial of the motion, this court has read the record and is familiar with the facts, but it bears repeating what her counsel told the court on the morning of trial. That he had filed the emergency motion to continue more, and then got to argue it on the morning of trial.
Here's
Sure.
kind of a difficult rub with the position. About a month before the CMC,
Sure.
Mr. Otero says, ready to go.
That is correct.
So it puts the trial judge in a pretty awkward position, right? I mean, we gotta be able to accept the lawyer's representation at CMC, that, hey, we're good to go. Just help with that part.
To err is human.
Yeah, for
To
sure.
forgive.
That's why it
Mi-
doesn't work.
Mr. Otero, bless his soul, he most certainly erred when he told the judge, I will be ready. And he tried to explain to the court why he believed in good faith that he would be ready. It was his understanding at that time that the only matters that were going to proceed were going to be time-sharing issues, not the financial issues. And even the time-sharing issues, on a case of this magnitude, he'd invested a lot of stock in himself to say that he'd be ready in just 17 days to present witnesses and to have his client ready and to have his trial exhibits.
For the time sharing.
For the time sharing. And then, of course, that's not the way this happened. There are different parties will say different things about why the settlement that appeared to all to be imminent fell through, but it most certainly fell through. And when it did, Mr. Otero was stuck between the proverbial rock and the hard place, the exact idiom that he gave to the trial court, when he recognized, okay, well, now I have to try to do both. And then he stopped preparing for the trial, time sharing utterly, tried to switch over to the other, and ultimately failed to do either in any competent fashion. And he wasn't subtle with the court. He was, admirable and yet shocking with his recognition to the lower court as to what his situation was.
Despite his protestations and his pleas for a contagion, I don't see anywhere in the record where he specified and identified with clarity what was outstanding. Judge Hellinger repeated himself multiple times about this family trust in 2014, 2011. Well,
Sure.
there was no ownership, so it's not a miracle.
That's exactly the issue, Your Honor. We don't know.
Well, Mr. Campbell was there every time. I mean, you're in a
Sure.
poor position.
Well, and Your Honor, that is exactly part of it, and I very much appreciate preservation issues and why it's important for the lower court's counsel to identify things to the court, but he can only identify that which he knows and understands.
I know about this family trust.
Well, and
Certainly. But see, what happens early on, a year or two before, where there's competent counsel, I don't think anybody disagrees that all the counsel Ms. Morgan had were competent.
sure,
Every one of them.
prior
They're
to,
all experienced, everyone.
and the last counsel
And
would have
they
been
all
competent
agreed-
given time.
They all agreed that the CPAs would get together. CPAs agreed. They all got together. And then Judge Hellinger, to his credit, had a follow-up hearing to make sure he was satisfied and everybody else was satisfied that they were working together. So it's not like he didn't monitor this case. So once it comes time with Mr. Otero, who has a change of heart, well, I do need a continuance. He doesn't identify specifically, you're supposed to,
Sure.
what's outstanding. He
And
just simply says, I thought we had a settlement. Well, tough. We've all been there.
except he doesn't just say that I thought we had a settlement. He explains to the court how he's had a panic attack, he's had anxiety attacks. He is, in his mind, and I think the record bears it out, violating the rules of professional conduct to proceed. He doesn't have trial exhibits. He hasn't prepped his witnesses on what the direct's going to be, on lines of cross-examination. Basic MOA on trial standards 101, stuff that he would have loved to have gotten the opportunity to have got his hands on and figured out given more time. But it's simply, he could not accomplish it given the amount of time once he found out. And of course, hindsight's 20/20, he should have realized an almost settlement is not a settlement. I know that, this court knows that. But Mr. Otero, in good faith, wanted to write in and help, and then he realized not only can he not help, he was going to hurt, and he did hurt, and not for his fault. Well, except for it was his fault in that he couldn't be prepared, but the reasons he couldn't be prepared again is the incredible shortness of time, and we do have those discovery issues, Your Honor, that we know that there's a trust and that there's complicated. I mean, and that's the amazing thing about this. We have a potentially $72 million estate, or whether it's $8 million or 72, and that's what the trial court recognized. And don't get me wrong, Your Honor, I think that our trial judge did an admirable job with many things in this issue. He clearly attempted to get his arms around this case and to shoulder it forward. But the problem is, at the end, he pushed too hard. He gave a push when that push broke the covenant between court and party as to what proper due process is. That trial court had earlier told the husband that, no, I am going to overrule your objections to discovery. And he told them, when you have a financial affidavit that says one thing and then a personal financial statement that says 7 times that, and we're talking about 7 times with a lot of zeros behind it, that this court that opens up the door to an incredible amount of discovery to see what the deal is, it just does. And so he granted that motion to compel, but then as this court recognized, he had the CPAs talk and promised, even at the eve of trial, there was a straw poll conducted by the same court who said, okay, who here thinks that we've got our discovery issues ironed out? And the 2, as everyone describes, competent counsel for the former wife said no. Both her CPAs said no. And of course the other side said, yes, we think it's all ironed out. This is not the way discovery works. One side doesn't get to decide when it's ironed out and when it's not. It's got to be the court who actually does it. And here, we just didn't have that. And without that full and fair discovery first, even if Mr. Otero had had a year beforehand to plan, he still would have had a difficult time with the case.
Can you remind me, did your client, through counsel or otherwise, make a request to bifurcate?
There was.
And I ask because looking at the record, it's a little over 2 years from filing the petition till when, this trial ultimately happens. You've got time sharing, you've got kids, family law judges are on marching orders.
Sure.
Get that part pinned down. I'll make that request to Judge. Can you at least just bifurcate so we just address the time sharing issues?
It is my understanding that Mr. Otero did make that request orally to the judge. He definitely did not make a formal motion to bifurcate and file something like that, but it is, my review of the record was that was a request and the judge wasn't at that point having anything of any of it. And we understand that, we get it, but it just at the end of the day proved not to be fair. And so really this is what it boils down to, is that word fairness, that we all know that there's no perfect cake that gets baked at a trial, that there are going to be eggshells that find their way in, but we ask for basic fairness. We ask that each party get the opportunity to properly present their case. And here, Mr. Otero, in like I said, amazing candor to the court, told the court that I will be violating the rules of professional conduct. If this were a Japanese sword ceremony, Mr. Otero's body would have been lying on the floor before the court, and the court said, we're still going, you're still doing it, and we will proceed. And the transcript reveals exactly what the expected result was. The witnesses were not prepared. The witnesses had to be cross-examined by, in the instance of Buchanan, she was cross-examined simultaneously by the opposing counsel, by the judge, and by the other CPA who was allowed to, in real time, cross-check her information, and there was no opportunity to have the same go in reverse because Mr. Otero simply didn't know the information, couldn't know the information with which to do so. This was not a fair fight, and that's all Ms. Morgan asks, is that opportunity to have that fair fight, and when she does get that opportunity to have a fair fight, consistent with this court's longstanding doctrines in Benfrey versus Cape Lumber Company and other cases, that discovery should be opened up to allow for the long-awaited answers to those motions to compel that she's been trying to get since 2020 on this 2022 case, that she'd be allowed to receive that information. So I know I reserved only 5 minutes for my rebuttal, but if the court will allow, I'll reserve the remainder, and I will allow Ms. Lopez to correct my errors.
Good morning.
Good morning. Lindsay Lopez on behalf of Brett Morgan. We're asking you to affirm the final judgment because the trial court did not abuse its discretion in denying the motions to continue or in not allowing Ms. Morgan to have additional unidentified discovery. Still, as we sit here today, the discovery that she needs and what specific documents she's looking for have not been identified. Everyone agrees, all the cases, all of our briefs agree that these are matters in which the trial court has broad discretion. And so one of the cases that we cited, the Cargyle-Schrage case, says this has to be a circumstance in which no reasonable judge would have ever, with respect to the continuance, would have ever denied the continuance. And the record in this case reflects that the trial court bent over backwards to allow Ms. Morgan to have everything that she needed and all the resources that she needed to prepare for trial. And that any issues that she ultimately had in preparing for trial were the result of her having conflict with almost every individual involved throughout this litigation. And ultimately, as a result, going through 6 lawyers and 2 expert witnesses. And so there was never going to be a time where she had a long relationship with a lawyer who was going to be able to see her through the trial. And under these circumstances, there is no evidence that the trial court abused its discretion. And the crux of the argument is clearly that Ms. Morgan didn't get some still yet unidentified discovery that she needed to prepare for trial. And so there are really 3 important things we wanted to point out about the discovery. First is, throughout the briefs in argument today, there's no statement about what it was that she needed in addition, that she still didn't have and that would have allowed her to be ready for discovery. The second thing is that it appears that most of the discovery that she's looking for are to try and identify if there are any marital interests in these certain non-party entities. And there was a motion to compel that was filed related to those non-party entities. I will say, I disagree. I don't think the record reflects that any motion to compel was ever granted in this case. There's no order that compelled the husband to do anything else. That the court, at one point early in the case, entered an order where he didn't grant or deny the motion to compel and just had the parties agree to this process whereby the experts would exchange discovery, but it didn't compel Mr. Morgan to produce anything in particular, and it didn't find that he had violated any of his discovery obligations. It was just a new process because the court found that there were very good professionals involved and very good accountants involved, and that might be the most efficient way to determine what was marital and non-marital. And so at some point, Ms. Morgan's third attorney said there was a process followed with the non-party subpoenas. The court allowed them to be issued over Mr. Morgan's objection. The non-party entities had their own counsel. As Judge Sleet recognized, Mr. Campbell was involved in the process. The court set forth the whole framework. Mr. Maros filed what I would consider to be a pretty bare bones motion to compel and said, we still need more. Before that motion was heard, Mr. Maros moved to withdraw. There was a hearing on his motion to withdraw. Ms. Morgan was present at the hearing, and she said, so she had noticed that her lawyer was withdrawing. She knew her lawyer would be withdrawing, and she asked for that motion to compel to remain scheduled on December 17th, 2021. She said, I'm working on getting a new lawyer. I want this motion to compel to be heard. December 17th hearing comes, everyone shows up again, a large number of professionals, including counsel for the non-parties, and no new lawyer has appeared for Ms. Morgan, and she doesn't appear at the hearing either. And so that hearing on the motion to compel was heard in her absence. And at that point, the trial judge heard from the other professionals who were there. We don't have a transcript from that hearing, so there's no way for the court to look behind what happened to that hearing. But there was an order that was entered afterwards that said, I'm holding this motion in abeyance pending any further order, and right now the husband has no further obligation to produce anything else. And so that was entered in December of 2021. Maybe the order might have been entered in January of 2021, but it's right in that time period after that December 17th hearing, and no discovery issues come up for the next almost 7 months. A lot of discovery issues come up in the next 7 months, but they're discovery issues that are related to Ms. Morgan not producing things that she was required to produce. There are monthly case management conferences. There are orders from all of those, and they're fairly detailed orders where Judge Hellinger sets out all the issues that were being discussed at these hearings. At this point, Ms. Morgan has new counsel. She has counsel involved in all of these hearings. Many of these hearings she's attending herself, and there is no mention that there's this continued issue related to the motion to compel, that there's continued documentation needed from the husband. So I would say that to the extent that there were any issues related to that motion to compel, they were waived because they were never raised again until July 8th, 2022, right before the pretrial conference. There was a pretrial statement that has sort of a general statement that there's still discovery outstanding and a laundry list of entities that she says she still needs discovery from, but it hasn't been raised in the intervening 7 months, and there was no obligation in intervening 7 months for the husband to produce anything. The other really important thing to keep in mind about discovery is that when the wife filed a motion to continue, really on the eve of trial on October 26th, the trial court heard it that day. The trial court said, you're still saying you need discovery. I want to hear you on this. Even though this has not come up before, there was a motion for reconsideration that was filed. Unfortunately, it wasn't heard because both of the wife's fourth and fifth lawyers moved to withdraw on an expedited basis. Her fourth lawyer, Ms. Evelsizer, had said she was willing to stay on to work through the discovery issues. And then she came back to the court in a joint motion with Mr. Goodman and said, we need to get out now. And the trial court's statements on the record at the trial, at least, there's again no transcript from that hearing, but the trial court says that was due to threats that were made against those lawyers by Ms. Morgan. So her lawyers said, we need to get out now. And the hearing on the motion for reconsideration was not heard because her lawyers withdrew because she was threatening them. And then, but still, when this issue comes up in the motion to continue, the court says, I want to hear you. What is it you need? And scheduled a lengthy evidentiary hearing. There's no transcript from that hearing, but there is testimony at trial where the trial court asks Mr. Otero multiple times, we had an evidentiary hearing. I asked you, is there anything else that you need? Anything else you need? Anything else you want to present to me? You agree that I did that, correct? And Mr. Otero says, yes, Your Honor, I agree. Correct, I agree. And the court says you didn't identify anything you needed in your motion to continue. You still haven't told me, you haven't given me any evidence that these are marital properties that you need more discovery regarding. And so in this case, the discovery was completed. A continuance would not have yielded anything more because as the trial court correctly found, and there's no record on which this court can reverse, he had a full evidentiary hearing. He allowed the parties to present evidence regarding any additional documents they needed, any additional evidence that there are other marital interests. And Ms. Morgan's lawyer was not able to identify anything. And so there's no prejudice in allowing this case to finally come to a conclusion. And to the contrary, there would have been really significant prejudice to Mr. Morgan. Goes without saying, this is a very contentious divorce. There were extremely difficult issues throughout this divorce. And the trial court recognized that. And when he gave his oral ruling on the second motion to continue, he said, look, I recognize that bringing the case to a conclusion, that this has been extremely contentious. In my experience, it's very difficult for a child to live under these circumstances. I recognize that a final judgment might not solve everything, but I think a lot of times it does. And in this case, I need to bring this case to a conclusion because it has been so contentious. And I have given, for a year and a half, Mr. Morgan has been asking us to please bring this case to a conclusion. And I've been resisting it because I wanted to give Ms. Morgan every opportunity she could possibly have to be ready for trial, but it's time now. He would have been greatly prejudiced. It's similar to the court's analysis in the Kalki case. Everyone was there, the counsel was ready, the parties were ready, but this is even more than just the sort of general getting ready for trial and getting prejudiced.
I want to clarify something. Am I correct in understanding the records that the child wasn't the mother wasn't in any kind of therapy prior to entry of the final judgment that requires her to be in therapy?
I believe what she testified to was that she was in some kind of therapy, but she wasn't doing the type of therapy that the court believed. Right. I think it was DBT therapy.
Yeah, DBT through the guardian ad litem.
Right, and the court
and that started pursuant to the final judgment.
I don't know.
It looks like it.
I believe that there are. I don't know exactly what the status is. I know that the parties are continuing to work through their time sharing issues and continuing to work through and try and do everything they can in the best interest of the child. I don't know exactly what's happening.
It's a pretty detailed final judgment with respect to the issues with the child.
Right, and I do recognize, of course, that they haven't appealed the issues related to the time sharing, and the purpose of us including that background.
Well, no, but you were making the comment about the trial court being concerned about getting this done.
Yes,
One of the things that was effectuated by getting this done is getting that mother in therapy.
absolutely. And that's one of the things that we just wanted the court to understand, that this wasn't happening in a vacuum. There were significant issues throughout the case. And there's also the email that we cited to that the mother basically said, I'm getting a new lawyer now. I'm going to keep this going forever unless you agree to the offer that I just made to you. And so under these circumstances, there were reasons to bring this case to a close. And right now, there's still no identified documents that she still needed, where the trial court has looked at, had an evidentiary hearing, and looked at the evidence, allowed the parties to present anything they wanted to, and ultimately said, there's not one shred of evidence that any of these additional entities were either owned by the husband or marital property. And where the case has gone on for 2.5 years, it was time to bring the case to a close, and the trial court did not abuse its discretion. Unless the court has any other questions, we will rest on our briefs in the record.
Thank you. We have 5 minutes.
Thank you, Your Honor. First, to address Judge Kelly's question, that there was, as recently as October of 2021, the guardian ad litem report that the mother had actually taken steps toward therapy, and that she recommended that the mother and the child overnights be resumed because of the strengthening relationship. This is not to say that there weren't significant issues and that those issues needed to be worked through, but I think if we can learn anything from Simone Biles' ability to have mental issues, to get them treated, and to come back stronger than ever, everyone deserves that opportunity. To Judge Lucas,
I don't question that,
Sure.
but I was just wondering in terms of the trial court's thought process, how important it was to make sure that the mom was getting as much help as she could.
and we understand that, Your Honor, but the issue is here that of all the circumstances that are available for a judge to consider on continuance, best interest of the child is huge, but it's not the prejudice to the other side that's the third factor. The third factor is not prejudice to the overall family structure, and it is prejudice to Mr. Morgan. And Mr. Morgan didn't have any prejudice other than the traditional expenditure of more fees, and that's unfortunately part and parcel of litigation. This court has said so several times. What is important, Judge Lucas indicated the opportunity was certainly available to the court to rectify any issues it saw with regard to the child care and the timeshare issues, including therapy for parents, both or neither, by holding that part of the trial. That would have actually killed 2 birds with 1 stone, because Mr. Otero's motion for continuance was based strongly on the fact that all of this overwhelming financial information couldn't be processed, and he didn't have time to properly prepare his clients. If the judge said, look, we will hold off on that, but we're going forward on the timeshare. If that was the urgent call, that could have been dealt with. But unfortunately, the bathwater went out with the baby in this instance. The judge pushed everything forward, and it is incorrect to say that there was no specification of all of the documents that were missing, that the former counsel, just 2 months prior to trial, had filed her motions with detailed letters saying, we're missing this, we're missing this, we're missing this, we're missing this. That at trial, even without the ability to properly prepare, her CPA, who hadn't even been funded to appear until the day before the trial, that she identified a laundry list of items, and these items are included on pages 20 and 21 of the reply brief. Missing information regarding management company, missing information regarding this trust, missing information on an F1 Empower. There are record citations for each and every one of these 12 or more items. And even the one that's admitted by the other side in their brief, there's some missing Amex items. That's far understating what this means. There were multiple Amex accounts that Mr. Morgan controlled. And if you're missing multiple statements from different Amex accounts, the testimony from the CPA was that I can't piece together what goes to what. Her ability to make any reasonable argument on behalf of Ms. Morgan was severely impaired by the lack of known discovery. This wasn't an ambiguous issue. This wasn't an issue that had been waived. In fact, part of the period of time when we just heard about the waiver concept, the trial court abated discovery even though we only have 2 years, one of those years, the judge said, we're putting the time out on financial discovery. Well, that's fine. You're going to bifurcate and do the financial later because you want to push forward on these urgent issues involving time sharing. But that didn't happen. The judge forced this 7-8 digit figure estate into a truncated hearing where the former wife was forced to fight essentially with both hands tied behind her back because her attorney was punchless. He had no ability to prepare. He had no trial preparation. He had no witness exhibits. He had nothing. And that's not fair to Ms. Morgan. It's not fair to this court. It's not fair to the proceedings of justice. So for each of these reasons, Ms. Morgan respectfully requests this court to reverse and remand, acknowledging the need for trial courts to push forward on cases when it can, but in certain circumstances. The language of this court was, in certain circumstances, the denial of a continuance may create an injustice which outweighs the policy of not disturbing the trial court's ruling absent an abuse of discretion. That was this court in Fazig versus Fazig. And by the way, in Fazig versus Fazig, there was no motion to compel filed at all. And the court said the lack of disclosure means you need to have granted that continuance. Here, we have 10. I'm right at it, Your Honor. So here, the facts easily fit Ramadan versus Ramadan, Fazig versus Fazig, and other precedent of this court to reverse and remand to allow for a fair trial for these litigants. Thank you, Your Honor.
Thank you both. We had a visitor today. Guest watching.
Yes, how are you? Good morning, Attorney